May I first introduce you Professor Hennette-VAUCHEZ from the University of Paris and Nanterre, and she is a huge human rights specialist, and she works mainly on human rights issues. She wrote a book in French about public freedom or something, liberté publique, and she will work with you during the first days of the session. On human rights and technical progress, there was a lot of issues. So I chose two main issues, medicine and then data protection. But at the end, you will have a very good and famous specialist of the global issue of technical progress, Professor Rodota, which is in Italian, and you will try to reconcile all the different views you had during this week. I think if you have any problem, please talk to me. I will be there around during the lecture and during the break, except Wednesday. So if you have practical or different questions, please don't hesitate. I am here for you. So I will let the floor to Professor Hennette-VAUCHEZ when she is ready, but perhaps I will. It works. You receive also document on Canvas? Also Canvas? There are open on Canvas. Different lectures. Can we start?
Yes, we can.
Please, can you, in few words, introduce yourself for Professor VAUCHEZ? We will begin here, lady. And what is your name and what are you doing?
Good morning, my name is Valentina, I am Russian, and I want to say that I chose this class too because I'm interested in medicine and law, because my undergraduate thesis is connected with counterfeit medical products, and I will analyze how it involved on human rights and business. Because
Thank you.
Thank you.
Hi, my name is Maria. I'm from Russia as well. I'm doing a master's degree in Penn State University, and my master's thesis is connected to the terrorism and especially how to protect human rights while countering that terrorism. So I picked this cluster because I want to develop more on the technology and how technology connects with public, what are surveillance, and all this.
Thank you.
Good morning. My name is Alexey. I'm from Moscow. I'm first year student of the master program International Protection of Human Rights of the People's Friendship University of Russia. I chose this cluster because the influence of human rights is a really difficult but interesting thing. So I'm glad to be here.
Thank you.
It's you.
Okay. Hello, my name is Carmela. I'm Romanian. I work with the Registry of the European Court of Human Rights. Why I chose this cluster? I have a prior degree in biology, so I was trying somehow to combine my prior knowledge with my interest in human rights and my present activity.
Okay, great.
Hello, I'm Agnes Nikolagina. I work for the Human Rights NGO, Baltic Human Rights Society. Our organization works in Baltic region in the area of human rights education. So, and I'm here especially in this cluster to actually we are trying to cover more urgent issues for society by our human rights education materials and self-help tools. So I think this is a topic which is very important, not only for some vulnerable groups, but for society in general and for young generations, that we should also cover in our materials. So I hope to get some new inspirations and ideas which areas and issues to address for society to help them better understand all these challenges. Thank you.
Me?
You, please.
Hello. My name is Naira. I'm from Armenia, but I'm doing my master in international human rights while at the University of Nottingham. This cluster is very specific, and I think that I don't cover technical progress and human rights in my program, so I think this is good for me to know more. Thank you.
Hello, my name is Natalia. I'm from Russia also, from Kazan State University, Kazan Now University. So, and I also don't have back degree in law, but I was also studying biology. And this cluster is very interesting for me because nowadays the modern medicine is not at the same level in every country. So, who is worthy to use it? This is the question that I'm trying to find here. Okay.
Good morning. My name is Guzal. I'm from Russia, Kazan State University, and I have chosen this cluster because for me it is very interesting, both areas, and because medical area is a very topical issue in Russia. We have many problems connected with this thing. And then the second area is also interesting for me because my master thesis is connected with protection of human rights in and intellectual property. Human rights connected with intellectual property. Thank you.
Hello, my name is Cristina Teodorapov. I'm working for the Constitutional Court of Romania. I am doing also a PhD in the criminal medical responsibility in Romania, and this program is very important for me because I'm starting to work at my thesis.
Yeah.
And the school is already very interesting for me because it has been a very long time since I did not have such a different environment. I mean, with people from different fields, not only prosecutors, judges, and advocates. So it's very important for me to be here.
Hello, my name is Ioana Iliescu. I work as an assistant lawyer for the Registry of the European Court of Human Rights. I'm interested in the relation between human rights and health, and also law and medicine, and in the protection, the legal protection of vulnerable persons. And I hope in the future I will go a bit into the area of research in this topic.
Hello.
Yes, sir, please.
Sorry. Oh,
Wow.
started right. Dramatic. My name is Lila Protopapa. I come from Quebec City, Canada. I'm here today because Venice attracted me here, of course, but also as well. I don't have any background in human rights and technologies, but I'm interested in the medicine topic because my father was affected tragically by it. Not going into that area right now, but it is something that hit home, and it's something I want to explore, and maybe I could take this to another level. So that's the inspiration behind it. My background is international relations, but in the international financial crisis, but this is very interesting on a human level, on a human crisis. Thank you.
Yes, please.
Hi everybody, my name is Michaela and I come from Slovakia, but I was studying in England international relations mainly, and I'm starting also from September human rights and IR in London. But during this year, while this actually new technologies, I was doing innovation summit in European Parliament, and also I was working on the GlobSec conference, and my project was innovation forum and energy forum that we launched very successfully. So somehow I'm trying to connect those both areas like human rights and technology, because I do believe they can switch together.
My name is Lakshmi Gopal. I'm beginning from India and the US. I'm beginning a degree in the fall, and I want to focus on criminal justice constitution and rights, and I think that human rights is becoming the civil rights for the world. And so I want to understand the human rights discourse, especially with regard to technology, because I think these two discourses are going to have a fundamental impact on the way we treat each other in the future. So I'm interested to know what's happening in Europe, especially.
Yes.
Hello, my name is Artyom. I'm from Russia. Now I work at the European Court of Human Rights. So my interest in these clusters and well, it's basically twofold. It's first in the matter, and second is my professional interest in getting the state of art information, the standard of legal knowledge, because the cases in that area are quite rare. So I'd like to have first-hand information.
Okay.
Hello, my name is Evgeny Borisenko. We work together with Atom. I'm a lawyer at the European Court of Human Rights. I'm a graduate of the Strasbourg University. I mainly chose this cluster because, well, when you work at the European Court of Human Rights, you are frequently called to treat cases on freedom of expression, on fair proceedings, or physical integrity. So for me, I think it would allow me to know more and to get some more information on the issue.
So, the three newcomers, can you introduce you?
Yeah, sorry for being
No,
late. My name is Vladimir Versnov. I am from Bulgaria. I work as a government agent, and I'm very interested in new technologies, and that's why I have chosen this class.
Hi, my name is Veselina Kristova. I'm also from Bulgaria. I work as a government agent in the Ministry of Justice, Directorate Procedural Representation of the Republic of Bulgaria before the European Court of Human Rights.
Hello, my name is Vizhira Lazarova, also from Bulgaria. We work together. I work as a junior expert in the same directorate.
Thank you. So, thank you very much. Stephanie, the floor is yours.
Okay, thank you. So thanks for introducing yourselves. I remember none of your names, which is fine, but at least I have a little notion of who you are and what you do. And I'm very happy to be here, and we'll be seeing a lot of each other in the course of today and tomorrow. And as I believe you have seen on the program that was circulated, my project is to talk with you about two main topics and try to do some exploration of a third topic. So the first topic that I want to address is the topic of assisted reproduction that I'll be talking about for the two sessions we have this morning. Tomorrow I'll move on to another topic at the other end of life, if I can say, which is the topic of organ transplantation. And this afternoon we'll do a little sort of exploratory discussion around particular issues of human genetics and try to see what are the topics, what are the ways in which the issue of human genetics is currently intersecting with legal issues. Okay, so this is a little bit the map of what I was planning on talking about. As Jean-Paul said, I'm Stéphanie Hennette-Vauchez. I'm a professor at the University of Paris-Ouest Nanterre in France, where I'm also the head of the master's program in human rights. And I've been working a lot on the intersection of law and medicine. And so I'm going to start the first topic on assisted reproduction this morning. And I guess I'll start with the sort of kind of longer introduction that is not particularly legal, but that is really trying to share with you my understanding of what are the ways in which the issue of assisted reproduction is today, nowadays, rising a number of social, ethical, legal questions. And then we'll move on to the more legal perspective in trying to understand where the law stands vis-a-vis assisted reproduction. Is there anything like a right to procreate? And throughout my whole presentation this morning, or my two segments of the presentation this morning, what I'm going to try to do with you is try to invite you to think about the ways in which the paradigm of human rights and the paradigm of the market, especially within the European context, are intersecting, and try to explore the ways in which they may have different logics and they may have different answers to similar questions, right? So basically, you know, there'll be a number of moments where I'll try to invite you to think about the ways in which the European Court of Human Rights, for example, and the European Court of Justice may have different legal discourses or different legal answers because they mobilize different legal categories and different logics on issues of assisted reproduction. And this is also a way of inviting you to think that assisted reproduction is really a very broad topic, and that is not only something that appears in the shape of ethics and human rights and values and morals, but it is also something about the circulation of goods and services, and it also has a sort of economic or market-oriented dimension to it, okay? So this is the sort of big thread of what I'll be talking about this morning. Before I really start, I want to really invite you to interrupt me. This doesn't need to be a sort of ground lecture, and I'm very happy to try to answer any question you'll have. As I speak more, you will see that I speak faster, and you can stop me, you can wave, you can do whatever is needed. And also, I have a lot to say. There's many, many things we could talk about. So really, if you want to stop on a particular point, or if you want to, you know, rewind and, you know, go in whatever direction, please really feel very free to interact, okay? So, first topic for our little encounter of today and tomorrow, as I said, is assisted reproduction. So, you may or may not know that 1978 is the year in which the first test tube baby was born. It was in the UK. Her name was Louise Brown. And since this first test tube baby was born, assisted reproduction techniques have really multiplied, and they have triggered various regulatory responses throughout the world. As I said, I'm going to start out a little introduction talking about assisted reproduction as a medical and social fact, and try to lay the ground before we move on to the legal dimensions of it. So basically, one of the core techniques of assisted reproduction is IVF, in vitro fertilization, right? So when eggs and sperm are mixed into a tube in vitro. And this practice over the past 30, 40 years has really shifted from artisanal to industrial, right? So this is really now a technique that is very medical, very that is very scientific, which really changes, of course, from the first testimonies we have of artificial insemination throughout the world. I think the first story about artificial insemination was published in a journal called Medical World in 1909, okay? And it related an artificial insemination that was supposed to have taken place 25 years prior, so at the end of the 19th century, in Philadelphia. And the story around this artificial insemination is interesting because the story was the story of a couple who came to see a physician because they could not have children. And the physician understood that the cause for the sterility, for the infertility, was on the side of the man. And he decided, with the husband, with the man of the couple who came to consult, he decided that they would put the wife to sleep. They will not inform her of anything. They would take sperm from one of the students in the medical faculty, and they would do artificial insemination. This is not in vitro, this is 18 something, right? But it was artisanal insemination. The reason for which I'm telling you this story is that it's very interesting that this is the first story we have about artificial insemination because it conveys the three pillars on which the practice of IVF later developed. What are these three pillars? They are first the power of physicians, because here it's really the physician who is in charge, of course, right? So artificial insemination is really about the power of physicians. The second pillar of this story is also a story of secrecy, because the woman is not even really aware of what is going on. She is put to sleep, and this is a deliberate choice of the physician and the husband together. We will go back to why there is this secrecy, but this is a very characteristic feature of the ways in which assisted reproductive technologies have evolved over time. And the third pillar of this first instance of artificial insemination is the selection of donors, right? The donor here was a person, was a male on the medical staff. And throughout the story of artificial reproductive techniques, there is a great anxieties around the selection of donors, right? Who is a suitable donor? This is something that we're going to come back to. So power of physicians, secrecy, and selection of donors are three elements that we see in this first story and that we're going to see throughout in the development of assisted reproductive technologies. So one of the things that we see, if we move on to today, what is assisted reproduction techniques today? You can just Google, maybe you've done this already, and you'll find loads of information over the internet, right? So if you're looking, for example, for how this story that I just told you about would take place today, and you're in Europe, this is what you're going to find. This is the website of the greatest sperm bank in Europe. It's a Danish sperm bank. And there's a number of interesting things that you can see on this website. You can see that we're talking about a donor catalog. You can see that we're talking about available donor information. You can have audio interviews of donors. You can have baby photos of the donors. You can have an extended profile. If you click and you move on to the next page, this is what you're going to get. So you're going to have a list, okay, with names, with race and ethnicity information. You're going to have information about the eyes, the color of the hair, the height, the weight. You're going to have information about the education of the donor. You're going to have the blood type. And you're going to have the status that is non-contact or open, which means basically, is the donor refusing, is he claiming absolute anonymity, or is he open to future contact with potential children that would be born throughout IVF practiced on the basis of the sperm donation. This is interesting. This is one of the shapes that assisted reproduction techniques are taking today. This is in Europe again. This is a model that, of course, is pushed to an extreme in countries like the United States, for example, where the model of sperm and gametes in general donation is really a private model where you have commercial sperm banks or commercial egg clinics. These are places where donor selection is practiced, right? So if you're a potential recipient, you come and you say, okay, I want a Caucasian donor with great height and blue eyes and whatever. And this is really important because this is a model where it is believed that supplying recipients, so couples or people who come to benefit from donation, supplying them with more information becomes an explicit business strategy, right? So you think that your clients need to have all this information to make a decision about the kind of donor that they want. There is another model. This is one of the models that is governing assisted reproductive technologies today. There's another model that is less of a private model, but is more a more heavily regulated model, a more publicly regulated model. In countries like France, for example, sperm banks started out in the 80s and the 70s as commercial entities, but soon enough they were submitted to a number of very heavy administrative regulations that aim at guaranteeing uniform safety rules. And the major consequence of this is that sperm banks or egg clinics are not an open industry, right? In order to become a sperm bank, you have to have prior authorization. This is not just a business or a market that you can come into freely and say, okay, I'm opening a sperm bank, right? You need to have a whole series of administrative authorizations to engage in the practice. And the other big difference is that donor selection is not an option in this second model, in this more heavily administratively regulated model. It's not an option that is offered to recipients. Donor selection is perceived as rather unethical, right, as rather problematic. So if you go to a country like France, you will not find those sperm banks, and you will not find this process of donor selection. Now this is interesting because it raises the question, how does it happen then? You know, if recipients are not selecting the donor, who is selecting the donor? Of course, someone is selecting the donor. Physicians, medical staff is selecting the donor. Physicians are in charge of doing a number of matching operations in order to make sure that there is no major contrast between a couple, for example, that has come to a sperm bank for fertility issues and the children that might result from the in vitro fertilization, right? So basically, physicians are going to be making sure that skin color, hair texture, maybe eye color, maybe even blood type are going to match, right? This is the responsibility of the physicians. The reason for which I'm explaining this is that it's very important to understand that when you have the physicians in charge of doing the matching, what you're really doing is that you're allowing for an illusion of natural procreation to take place, right? The way in which physicians understand their responsibility of doing the matching is to allow for the families who have come to the sperm bank to maybe never say to the kid that they were born out of artificial reproductive techniques, right? If you're matching the skin color, the height, the hair texture, the blood type, what you're really doing is that you're allowing for the secrecy around the fact that assisted reproductive technology even took place to be maintained throughout the whole life of the family, right? This, of course, is a very different model, right? Because, of course, when you have recipients choosing, they might choose a match for preserving the secrecy, but they might not, right? So you have here a different perspective. This is also interesting because this is a very contemporary issue that we might see a lot of changes in the coming years. Why? Because as you are well aware, there's a growing number of countries in Europe and in other parts of the world, of course, where the traditional norm of the family as constructed around a heterosexual couple is being challenged, right? And in an increasing number of countries, same-sex marriage is being recognized, and same-sex access to assisted reproductive techniques is also being recognized. So let's go back to the question of physicians in charge of the matching. If you're in a traditional understanding of the family with only heterosexual couples coming to assisted reproductive technologies, you can understand that physicians are preserving the possibility of secrecy. If you have same-sex couples coming to sperm banks, there's no secrecy to protect, right? Everyone is going to be aware that this particular couple of two women necessarily went to a sperm bank in order to procreate, right? It's impossible to do otherwise, right? So what then is left of the legitimacy of the physicians doing the matching? What is left of that? If the physicians were legitimate in doing the matching because they wanted to preserve the possibility of the secrecy, but now we are going to see an increasing number of cases in which the possibility of the secrecy is not even interesting, then it really raises the question of who is more legitimate to choose the donor. Is it the recipient or is it the physician? And if it is the physician, there's a whole series of questions that really appears to be more problematic. Why would the physicians be in a better position to choose the skin color of a sperm donor for a couple of two women? Why would the physician be in a better position to choose the eye color or the education background of a sperm donor than the couple of two women who want to have a child, right? So this is just one of the topics that is currently really gaining in saliency in the wide topic of assisted reproductive technologies, as the traditional understanding of families and of people who can access assisted reproductive technologies is changing, right? So the issue of donor selection and the issue of secrecy are really topics on which we're probably going to see a lot of changes in the near future. Now, of course, I'm not saying that donor selection is unproblematic or evident. And just to move on to my next slide, there's of course a lot of questions around donor selection. This is a very interesting book that was published a couple of years ago about a sperm bank that was created in the late 1980s in California. And as the title says, the project of the sperm bank was to have a Nobel Prize sperm bank, right? So of course it never really worked, because can you imagine a single Nobel Prize winner, you know, saying yes to some guy in California who has this crazy project of having a sperm bank with only sperm donations from Nobel Prize winners, right? So it never really worked in the sense that they never really was Nobel Prize donors. But this bank existed, and it was just unduly called a Nobel Prize sperm bank. The guy responsible for the sperm bank did go throughout mostly the United States. He would go to, you know, scientific congresses, the Congress of American Physics or Chemistry, and try to find very smart guys and persuade them to give to his sperm bank. And this is just a book about the story, but it's just one way of showing, of course, how easily you can fall into sort of premier sperm banks, on marketing options that of course raise all these questions in terms of human rights and ethics or biomedical ethics, right? So this is just a couple of preliminary observations to invite you to think of the complexity of the issue, even if you look only, for example, at sperm donation, right? So you have complex issues on who should choose a donor in a process of assisted reproduction. Should it be the recipients or should it be the physician? Is secrecy and the possibility of the illusion of natural procreation something that should be built in the model of assisted reproductive technologies? And again, we're going to see that this is running against a number of consolidating human rights, such as the right of everyone to know their origins, the right to identity, right? So we have all these issues. Even if you just look at what is a sperm bank, you already have all these issues coming to the fore, right? Sperm banks, of course, are only one part of assisted reproductive technologies, right? Sperm banks exist in order to allow procreation either to single women or to lesbian couples or to heterosexual couples where there is a problem of male infertility, right? Of course, the problem can be the other way around. Of course, there are instances of female infertility. And female fertility issues have led to egg donation, and even in a growing number of places, to egg conservation, what is called also egg freezing, for future use, right? So as far as female fertility is concerned, I just want to rapidly address these two issues. Egg donation, so donation for altruistic donation for infertile women, and also self-interested donation that would be called egg freezing. So what is interesting when you look at egg clinics or when you search for egg donation programs on the internet, you're always going to find a massive rhetoric of altruism, right? What you see here is, thank you for your interest in becoming an egg donor. It's the generosity of women like you who help make the dreams of becoming parents a reality for those struggling with infertility, right? This is one example. Another example that I just took from a French website. I just wanted you to look at the far right. It says, quelle donneuse de bonheur êtes-vous? Which means, what happiness provider are you, right? So what you're giving really is not eggs, is not biological material, it's happiness, right? So this is really a very strong rhetoric in the field of egg donation. Egg donation is a very interesting topic because, of course, some of you have prior degrees in biology. I guess I don't need to insist very much to attract your attention on the fact that egg donation is a much more risky and much more invasive procedure than sperm donation, right? Sperm donation, we all agree, is painless. Egg donation certainly isn't, right? Egg donation involves a very heavy hormonal treatment prior to the donation to stimulate the production of eggs. It involves anesthesia, which is always a risky procedure, and it involves invasive surgical retrieval of the eggs, right? So egg donation is really an invasive technique. What is very interesting is to look at, for us as lawyers or people interested in how law responds to these issues, is to see that in many countries, the legal regulation of these procedures talks about gametes, right? So it puts sperm and eggs on a par, right? It just talks about reproductive material without differentiating between sperm donation and egg donation. And this, of course, is rather problematic because it really isn't the same kind of procedure, right? So as lawyers, we really want to think about the sort of invisibilization of the particular challenges that assisted reproductive technologies weigh on women when you just talk, you know, on facially neutrally of donation of reproductive material, because we're really not talking about the same kinds of risks and procedure. The other interesting thing about egg donation is that it has been documented that there is a risk of pressure for women who are infertile to find and bring a donor when they need a donation themselves, right? So in many countries, what we've seen happen over the past 15 or 20 years is that if a woman is infertile, she will come to an assisted reproductive program. Very often there's long waiting lists and there's a number of issues with the waiting lists. And one of the ways in which you could run on the top of the waiting list is to come with a donor yourself, right? So this means that women are really put at pressure because they are a part of the bargaining process for people to actually be able to enter the donation programs. So this is really something that is an additional challenge for regulators in the field of assisted reproductive technologies today, okay? So that's for egg donation. But as I said, what we're also seeing developing is not egg donation for others, but egg conservation for oneself. And there's really two narratives about egg freezing, right? One narrative on egg freezing is a narrative of autonomy, control, and agency. One narrative is really picturing egg freezing as the ultimate gesture of control of women over their biological and reproductive life, right? So, you know, quite the ways in which maybe abortion or contraception in the 1960s and 70s was portrayed as the way to assert command and mastery over one's reproductive life, some narratives about egg freezing take the same rhetoric, right? You freeze your eggs when you are young, when they are of good quality, and you can use them. You don't want to have children when you're 22. This is what the narrative says, because you have so many other things to do in your life. So just freeze your eggs, and you'll use them when you're 40 or whatever, and you've achieved everything that you want to achieve in terms of education and professional achievements, right? This is one narrative about egg freezing. Now, of course, there is another narrative. The other narrative is a narrative about alienation, right? Maybe you've heard about these big companies, Apple, Google, Facebook, offering to their female employees to pay for them to freeze their eggs, right? Why would Apple or Google pay for their female employees to freeze their eggs? Well, because quite the same way you can say that women, when they're 22, want to earn degrees and achieve a professional career, well, Facebook wants them to be at full productivity at that time, right? They're young, they're innovative, they're educated, might as well keep them on the job instead of having them go on maternity leave, right? So there's also a rhetoric of alienation in this development of the technique of egg freezing, right? It is also, this is one of the ways in which you see that it is a complex issue. This is really a question on which a number of countries are going to determine themselves in the years to come. There's a number of countries in Europe where the law says nothing about egg freezing. There's a number of countries where the law is starting to say something. For example, in France, which is probably the example I know best, but I'm not going to go back to France every 2 minutes. But just on this one particular example, in France, egg freezing is possible only for women who have donated eggs for others, right? So the idea is egg donation is a risky business, and if you're doing the altruistic gesture of giving your eggs for infertile women, it is going to be offered to you the possibility of freezing some of your eggs for your possible future use, because in case your reproductive future is jeopardized by the donation you've made, at least you retain a chance of procreating for yourself, right? So this is a sort of limitative approach, but of course there are countries where there are no limitations and egg freezing is going to develop freely with none of that limitation, right? So this is going to be a regulatory challenge in many countries in the years to come. Okay, so finally, in the history, right? Surrogacy is not something new. If some of you are familiar with the Bible, this is the first picture that you see here is a drawing, a painting of Agar. Agar, who in the Genesis in the Old Testament was the servant of the couple formed by Abraham and Sarah. And Sarah was too old to procreate, and she asked her servant Agar to carry the child of her husband Abraham, and this is how Ismail was born, right? This is a biblical story of surrogacy, and this is to show that really it is not a new technique, right? Surrogacy is also something that is present in the world of literature. Here is the cover picture of a very famous novel by Margaret Atwood that was published in 1985. It's called The Handmaid's Tale. And The Handmaid's Tale is a novel about the American government being thrown over by a totalitarian Christian theocracy in which servants, handmaids, are made an underclass of reproduction, and a number of women have a social function of reproducing for others, right? So there's different classes of women in this new world, and some of them are really assigned to the sole social work of reproduction, right? So they bear the children of others. And these stories of surrogacy, of course, started having an impact in real life, in legal life, in the 1980s. And the middle picture that you have here is the cover of a book written by Mary Beth Whitehead, who is the surrogate mother of the very famous American Baby M case. The Baby M case is one of the leading cases, the first cases of a judicial battle around a surrogacy agreement that took place in New Jersey in 1988. Mary Beth Whitehead was the surrogate, and the Supreme Court of New Jersey in 1988 said that the surrogacy contract was void, was impossible to enforce, and maintained the rights of the surrogate over the child, right? So there was a commissioning couple. They made a contract with Mary Beth Whitehead. When the child was born, she decided she did not want to give up the child. And the Supreme Court of New Jersey gave her parental rights because she was the birth mother, right? This is just to show that surrogacy is really not a recent issue. However, you must have noticed that it is an issue that is all over the news most of the time these days, and it is regaining momentum, right? Surrogacy is anew becoming a very important topic. There's a number of reasons for that. The big difference between surrogacy as we discuss it today and as it is re-becoming a big legal and political issue and surrogacy in these stories is that when we talk about surrogacy today, most of the time we're talking about only gestational surrogacy. If you look at these stories, from the Bible story to the Mary Beth Whitehead stories, the women the women who are concerned by those stories were the genetic and the gestational mothers, right? When we talk about surrogacy today, most often we're talking about instances where the women are only gestational mothers. They're not genetic mothers, either because embryos are implanted into them, and usually either with the genetic material of the commissioning mother or of a third donor, but there's usually no donation of genetic material from the gestational mother, okay? This is very important because, first of all, in many countries, assisted reproductive technologies have led legal systems to redefine the place of genetics in the definition of parenthood, families, filiation, etc., right? So the fact that gestational mothers most often are no longer genetic mothers is something that increases the admissibility, not that it's admissible everywhere, but increases the pressure on legal system to declare surrogacy admissible, because in the same period of time, genetics has become an important element of parenthood in other instances where you don't necessarily have surrogacy, right? So a lot of legal systems over the past 30 years have decided that genetic material, genetic link, is important in the definition of parenthood. And when you have these new forms of surrogacy where women are only gestational but not genetic carriers, then you can say, well, as in other situations, you have a genetic link, so the woman who has the genetic link can be the mother, right? So this sort of shifts the discussion around gestation, around surrogacy. The other element that is very important in this redefinition of surrogacy as a medical practice is that the fact that women are only gestational mothers explains the increase, which is actually a boom, like a massive increase, in the practice of surrogacy in various parts of the world and in the globalization of the practice, right? So India, of course, is a country that has been very present in the debates over surrogacy over the past 10 years, because it is very well documented that India has become a very important place for people from other parts of the world to come and purchase the services of surrogate women, right? Very interestingly, there is a very problematic sort of racial, gender, class dimension to the globalized practice of surrogacy today. Surrogacy, as it is practiced today, really relies on a pattern that is very worrying for human rights standards. That, you know, if I want to put it in a very brief formulation, the pattern could be described as a pattern where rich people from the north come to poor women of the south in order to access their reproductive capacities, right? This is a trend that is documented in the social practice of surrogacy, with places like India, as I just said, becoming important platforms of international commerce of surrogacy. Why is there a racial dimension to this? There is a racial dimension to this because, of course, you could imagine that a number of, you know, let's say, I don't know, American, Canadian, French, whatever, people or couples who come to India or other parts of the Asian world to purchase surrogacy services, if they were to do assisted reproductive technologies without the need of a surrogate mother, okay? If they were to go to a sperm bank, for example, since they can do donor selection, as we said, they probably, you know, if they're Caucasian, they would probably choose for a Caucasian donor. If they're African American, they would probably choose for an African American donor. Here they can go to Asia and not care about the ethnicity of the woman who is carrying the child, because the woman who is carrying the child is no longer genetically related to the children. So there is no trace, no impact of surrogacy when the women are only gestational in terms of the race and ethnicity of the children who are being born. So this, of course, raises a major concern of sort of racial imbalance for human rights lawyers, that we will have, again, to say it in blunt words, white couples from the north using the reproductive capacities of brown and black women from the south. So here is for the racial dimension. The gender dimension, of course, is massive in the field of surrogacy. What is the problem with surrogacy is that it really assigns and reassigns women to this one prominent role of being in charge of the reproduction of political communities as a whole, right? So you have women, as we have the technique of surrogacy develop and widespread, you really have this sort of constant reaffirmation of the fact that the major role of women, the major contribution of women to society is reproduction. And the class dimension, of course, is very important. In fact, the class dimension you can see since the very beginnings of surrogacy being documented. Agar, as I said, was the servant of Abram and Sarah. Mary Beth Whitehead was a dropout of high school. Her husband was a janitor. They were maybe making, I think, I have the figure here, they were making in the 80s $28,000 per year. The commissioned parents, the couple who asked Mary Beth Whitehead to carry their child, were a couple of professionals. They were both lawyers. They were very well educated, and they made more in the range of $100,000 per year. So you do have this massive class dimension also to the practice of surrogacy from the outset and still continuing today, okay? So of course, as you see, surrogacy is not something new, but is something that is certainly raising a number of very difficult questions in terms of race, gender, and class inequalities as it is becoming a globalized practice, okay? So sperm banks, egg banks or egg clinics, surrogacy, these are like the three topics, the three places, the three ways of looking at assisted reproductive technologies, where you see that there's, of course, a wide range of human rights issues that are at stake. Okay? Do you have any questions on this? This is just my sort of introduction to map out the kind of topics that we're going to be talking about.
Yes, I think that I have one question, is that because we were talking about the class, I mentioned it among the people who use this field, but we didn't talk about those one who give these possibilities to other people, because I suppose that most of them are poor women who are able to do this. I mean, that usually I think that normal ladies that they don't do this.
You usually you think that?
No, like I mean from those people who are high educated and I don't know if they receive enough money, they don't do this.
Yeah, exactly. So that is the class dimension. The class dimension is that the documentation of the practice is that although it is not impossible, because you also have a lot of stories of surrogacy where, for example, you know, your sister cannot carry a child and you will do it for her, and you know, it's a very different issue, right? But the dominant model that is really consolidating and has been consolidating over the past 15 years or so is really the model that you're describing, right? Where of course there is a major class imbalance where, you know, women if they make a nice living, they're probably not going to engage in surrogacy. And if they're really poor, and in many countries, you know, one surrogacy contract is going to buy you a house, and two surrogacy contracts are going to buy you a house and education for your kid. So, of course, it's absolutely the sort of pattern that you're describing that is problematic for regulators throughout the world today. Any other comment or question?
Yeah, but the biblical story, interesting, with Agar, the servant, she actually raised Ishmael. It wasn't Sarah and Abraham, even if she procreated with Abraham, but it was her that raised the child.
Yeah.
So it's not the same dimension.
It's not the same, but it's still the child of Sarah and Abraham. The fact that servants would raise children, it is not really operative. I mean, you know, servants have raised children in many societies until the 19th century. The invention of motherhood and of the exclusive link between a mother and their child is very recent, right? So that was a very common social practice. What is interesting in the biblical story is that Ishmael is presented as the child of Sarah and Abraham. This is what I was pointing at.
I never saw it that way. I saw that, you know, she couldn't bear children, and obviously we needed to bear children.
Yeah.
So, you know, we had it with the servant, and she raised Ishmael. It wasn't Sarah that raised, because then
I
Sarah
know,
got
but it's not
pregnant.
raising the child that makes the mother in those times.
I know, but I can't parallel this story with surrogacy of this. Today's surrogacy.
No, I'm not saying it's the same kind. I'm just saying, you know, the story that women would carry children for other women is a universal in time, if I can say, story, right? That's what I'm trying to point at, right? Then there are major changes. I mean, of course, you know, the industrialization, the globalization, the severance of the link between gestation and genetic donation, etc. All this totally changes the practice, right?
Well, for sure, yeah. It has evolved to other levels, beyond the servant level, of course.
Yeah.
Has this link between or this break between the link of DNA and parenthood, has it affected things like paternity cases or cases in which the DNA has been central to outcomes for the child?
What do you mean by outcome?
Yeah, it is. Like who gets to look after the child?
Yeah, there are very diverse answers throughout the world to this question, right? So, for example, if you have a surrogacy contract in California, the gestational mother doesn't exist. She will not appear on the birth certificates, right? So she's like totally invisibilized. If you have surrogacy in Russia, for example, there's a case pending in front of the French Supreme Judicial Court that will give a ruling later this week. The the surrogate mother appears on the birth certificate. So of course, when then people travel and go back to their country, you're going to have very different issues of translating those birth certificates in the national law. So there's no one single answer to your question. It really depends on the level of acceptance of surrogacy, on the importance of genetic link in the construction of parenthood in the particular country. So it's impossible to give one answer to that. But you're right, I mean, this will give rise to a plurality of situations, of solutions. Yeah.
I see that the surrogacy is a practice, a common practice since like biblical times, let's say. But I think it's important to say that I think that in bourgeois societies, like in the ancient regime in 17th, 18th century, surrogacy was probably the answer to, well, let's say, rich women who do not want to carry a child. While now it's mainly the issue of women who can have a child, but they cannot carry this child together, they cannot give a birth. And that's why I'm a bit dubious about these debates going on and on, that we always talk about about women who surrogate mothers, but we do not talk about those women who cannot have children because of some medical problems. And just getting back to sperm donation, you described the two patterns. The first one being the sort of private system where you can choose everything, and the second one is highly regulated system like in France. And I wonder if there is any system which provides that sort of random choice, or does not exist.
I do not know of any system of random choice. I do not believe it exists. I have never heard anything like that. Random choice of
sperm donor.
No, I do not think it exists. I mean, I don't want to say it doesn't exist, because when you say that, you always have the one exception of some, I don't know. But really, I have never encountered reference to any system of that.
And another question, do you know how many countries provide for non-pecuniary surrogacy and countries provide only for like paid service?
Yeah. Again, I mean, it's legal as long as it's non-commercial. The problem is, when does it become commercial, right? Because of course, in the UK, if you're going to have a surrogate, you're going to pay for medical expenses, you're going to pay for decrease in wages if, for example, the woman needs to stop working, etc. But maybe you're going to buy, I don't know, a better bed, a pillow, clothes, for the surrogate. So the line between just compensating and remunerating is kind of blurred, right? So it's a little difficult. And actually, a number of interesting judgments, judicial rulings in the UK are struggling with this, because you have cases where it's alleged that there was remuneration in contradiction to the 1985 law. And judges are trying to see if the level of compensation was so high that, of course, it becomes remuneration, which is illegal. Right? So it's kind of difficult to say. Does that answer your question?
Yes.
Yeah. So I need to check the time. We have until 11. Okay. So if we move on a little, so this is my sort of mapping out of the issues. And now I'd like to move on to the more strictly legal question of, what are the legal resources for reflecting on all these issues of assisted reproduction. So, as I said briefly in introduction, what I'd like to do with you is, I could spend hours going into the detail of the diversity of the regulatory answers in many countries. So I could, tell you about the law in France, and tell you about the law in Germany, and tell you about the law in Italy. But, it's not very, it's a little boring, and it's just really okay, it's diverse, right? Countries have pretty much, most of the countries have now regulated assisted reproduction, right? It's right that you have, it's rare that you have no national law on assisted reproduction, and there's a diversity of options. So instead of going into the detail of this diversity, what I really want to share with you is the trends that we are seeing, at least at the level of Europe. So the first trend that we're seeing, and this maybe is the sort of human rights discourse or human rights model, is a trend where constitutional and supranational authorities are progressively shaping something like procreate, right? So this is one trend. This is a sort of human rights discourse that is progressively moving towards something like a right to procreate, right? And this would of course place a significant constraint on national legal orders, especially the more conservative ones, because some national legal orders have excluded some techniques of assisted reproductive technologies. We'll talk about Austria, for example, where donation of reproductive material is very restricted, right? We have other forms of restriction, for example, in Italy, where same-sex couples cannot access assisted reproduction, and many other countries, right? So if you have a right to procreate, then of course these national constraints are going to be under pressure, right? And the second trend that I want to talk about is what we could call the market model. The market model, which is maybe more focusing on the sort of EU particular dimension of assisted reproductive technologies. And we're going to try to reflect on what is to become of national diversity when freedoms of circulation guarantee a right of patients, of people, to circulate and circumvent, be it the case, restrictive or prohibitive rules in their countries of nationality or residence, right? So for example, in France, no access to assisted reproductive technologies for same-sex couples, but we know very well that lesbian women, French lesbian women, go to Belgium, where they can have sperm donation. And they come back, and if they're married, the partner can adopt the child of the one woman, right? So it's very interesting to see how freedoms of circulation internal to the European Union are kind of challenging the diversity of the national approaches of assisted reproductive technology. So this is the kind of trends that I'm going to try to map out for you. So if we look at international and European human rights law sources, we're not going to find any explicit acknowledgement or recognition of a right to procreate, right? The closest we're going to get is provisions that refer to the right to marry and found a family, right? So this is something that we're going to find in most international or human rights or European human rights instruments, right? So I've listed a number here. You have, for example, the Universal Declaration of Human Rights that says that men and women of full age have the right to marry and found a family. You have a somewhat similar provision in the International Covenant on Civil and Political Rights of 1966, the right of men and women of marriageable age to marry and found a family shall be recognized. The European Convention of Human Rights also echoes this right in the UN Covenant. You also have the Convention on the Elimination of Discrimination Against Women that was adopted within the United Nations in 1979 that says that states should take all appropriate measures to make sure that there are equal rights. This is the E provision that I'm focusing on. Equal rights to decide freely and responsibly on the number and spacing of their children and have access to information, education, and means to enable them to exercise their rights. Okay? And if you move on to the European Union Charter of Fundamental Rights, you'll find Article 9 that guarantees the right to marry and the right to found a family, right? So So basically, this is what we're finding. We're finding a number of provisions that guarantee the right to marry, and sometimes the right to marry and found a family. Okay? Okay, does this mean that there is a right to procreate? Does this mean that there is even a right to access assisted reproductive technology if you cannot procreate naturally for whatever reason? Okay? Probably not. Probably you cannot infer a right to procreate from those provisions for a number of reasons. First, if we go back, well, even this one, but to the Universal Declaration of Human Rights, 1948, ICCPR, 1966, European Convention of Human Rights, 1950, we're probably not even thinking of assisted reproductive technologies, right? Because as I said, I mean, the first test tube baby was born in 1978. This was not even an option, right? Even more so, if you think of the conception of a family that is behind the mind of the drafters of all these conventions, it's probably the very traditional family in the sense of the heterosexual family, and probably not the kind of families that are claiming today a right to procreate, like single families, homosexual families, etc. Probably not at all in the mindset of these provisions that recognize the right to found a family, right? So there's a number of reasons for which it would be very audacious and probably erroneous to try to infer a right to procreate or a right to access assisted reproductive technologies on the basis of these provisions. However, yeah?
Sorry, I just want to mention that we still have to interpret the convention in the light of the our situation today.
Yeah.
So maybe we can imply some rights of the maybe homosexual partners to have a family.
Of course. That's what I'm going to move to that. But it's a very important observation that actually really holds for the European Convention of Human Rights, doesn't necessarily hold for the other texts that I'm talking about, because the Universal Declaration of Human Rights has no interpreter. It's not even a convention, it's only a declaration, so there's nothing of the sort. There's no sort of technique of interpretation in the lights of the conditions of today, etc. And for the ICCPR, it's pretty much the same thing. I mean, of course you have the Human Rights Committee that is going to, interpret the ICCPR, but we don't have such a doctrine of evolutive interpretation as we have the European Convention of Human Rights. But absolutely, this is exactly what I was going to move on to in order to underline the fact that we have, in contrast with what I just said about these provisions, we have some interesting formulations, especially in the case law of the European Court of Human Rights, that contrast with this first reading of these provisions. So I'm going to show a number of excerpts of case law of the European Convention of Human Rights that show that the court has elevated the right to respect for both the decisions to become and not to become a parent. And the court has even mentioned the right to respect for people's decision to become genetic parents, right? So this is something that is very important for us, right? So I guess the two prominent cases in this sort of interpretation that I want to show you are the Evans versus the UK and Dixon versus the UK cases. The first one is behind me right now, and I just copy pasted one paragraph of the decision. Maybe you know this case. It's a very famous case where the applicant, Natalie Evans, was faced with the impossibility of, so she had been involved in an assisted reproductive protocol with her late husband, right? Embryos had been created, and the reason for which they had engaged in assisted reproduction technology is that she had ovarian cancer. And so the assisted reproductive technology was designed to produce embryos in order to safeguard her possibilities of future procreation, because she had to have impairment surgery. The problem is that the couple separated, and the British law requires the double consent of both partners at every stage of the assisted reproductive protocol. So when she recovered from her cancer and asked that the embryos that had been created be implanted into her for her to have children, he no longer agreed. And that impeded her from becoming a genetic mother. So she exhausted national remedies and brought the case before the European Court of Human Rights. And what is important here is that the court said a number of things. First, the court said that it was not disputed between the parties that Article 8, the right to private and family life, Article 8 is applicable, and that the case concerns the applicant's right to respect for her private life. The Grand Chamber agrees that private life, which is a broad term encompassing inter alia, aspects of an individual's physical and social identity, including the right to personal autonomy, personal development, and to establish and develop relationships with other human beings in the outside world, incorporates the right to respect for both the decisions to become and not to become a parent. So this is important because it is one of the first cases where the solemn Grand Chamber of the European Court of Human Rights mentions the fact that the decision to become or not to become a parent, so what we could call reproductive autonomy, is something that is encompassed under Article 8 of the Convention. So this is interesting because we see that it's not Article 12, right? Remember, Article 12 of the European Convention says right to marry and found a family. But really, this is not the grounds that the European Court is choosing when talking about reproductive autonomy. And it really situates itself on the grounds of Article 8, personal autonomy, includes reproductive autonomy, okay? As I said, there is a later case, Dixon versus the UK, where here the story was about an inmate, so a man who was serving a jail sentence. The sentence was long, and he argued that by the time he would get out of jail, his partner would no longer be of procreative age. So they required access to assisted reproductive technology and were denied, right? So here the court found a violation by reasoning on these grounds, still Article 8. The court considers that Article 8 is applicable to the applicant's complaint in that the refusal of artificial insemination facilities concern their private and family lives, which notions incorporate the right to respect for the decision to become genetic parents. So the operative word here, the addition to the previous case, the Evans versus the UK case, is genetic parent, right? Because here it's not only reproductive autonomy as a decision to become or not to become a parent, but it's really the respect for the desire to become a genetic parent, even if, as in the particular case, this necessarily entails access to assisted reproductive technology, right? So these are very interesting formulations where we see that although it's not on the grounds of Article 12, right to marry and right to found a family, we have interesting developments in the case law that seem to move towards, I'm not saying we're there, but seem to move towards this notion of a right to procreate, even if it includes the access to assisted reproductive technologies, because the ways in which the court has been talking about reproductive autonomy include this notion of becoming the right to respect for the decision to become a genetic parent, right? So these are interesting cases. I'm checking the time. I have a couple minutes left, right, before we have a break. So this does not, so as I said, this is just the indication of a trend, and it does not mean that the court has elevated a right to assisted reproductive technologies. Actually, far from that. because we have another case, the SH versus Austria case, that is also a Grand Chamber case of 2011, where the court was faced with the Austrian legislation that I mentioned before that is highly restrictive of the kind of assisted reproductive technologies that are possible, right? And in particular, the Austrian legislation at the time really only permitted in vitro fertilization with the genetic material of the two people of a couple. So third party was not possible. Third party donation was not possible, right? So it's only what you call autologous donation as opposed to heterologous donation, right? So artificial reproduction is okay, but only with the genetic material of the couple. So basically, assisted reproduction is really here to overcome sort of physical issues that impede the fertilization through sexual intercourse, but not the actual complete infertility of someone that would necessitate the donation of a material from a third party. And the court upheld this very restrictive understanding of assisted reproduction. It did recognize that the right to conceive a child and make use of medically assisted procreation is protected by Article 8, but it also found that the restrictive nature of the Austrian legislation was a permissible restriction under paragraph 2 of Article 8, right? Here we also have another affirmation of the fact that assisted reproductive technologies and the legitimacy of the desire people may have to access assisted reproductive technologies is protected under Article 8, right? So here we have another situation where an Italian couple of applicants was claiming access to assisted reproductive technologies, and in particular to prenatal genetic diagnosis, right, in order to avoid the transmission of a particular disease to the child, right? And this is also very restrictively tailored and in fact prohibited under Italian legislation. So the court here again acknowledged the fact that the desire of a couple to conceive a child unaffected by a genetic disease of which they are healthy carriers, and therefore their need to recourse to assisted reproductive technologies is under the protection of Article 8, right? And all of this, as I said, is really linked to the notion of personal autonomy that the court started developing in the Preddy versus the UK case of 2002, up to the date here. So you know the notion of personal autonomy, you know how important it is in the case law of Article 8. The concept of private life is a broad term. It covers physical and psychological integrity. It embraces aspects of an individual's physical and social identity. It includes, for example, gender identification, name and sexual orientation, and sexual life. And it also includes the right to personal development and the right to establish and develop relationships with other human beings and the outside world. So this is really the core notion of personal autonomy that the court defines as an important principle underlying the interpretation of Article 8, and that is really the basis on which the court is giving all the previous cases that I mentioned about reproductive autonomy, okay? So there is this strong construct of personal autonomy as encompassing reproductive autonomy. There are some affirmations in the case law that access to assisted reproductive technology potentially falls under the scope of Article 8. However, restrictions so far have often been upheld by the court as possible under paragraph 2 of Article 8, right? So to go back to the Austrian case that I was mentioning, the very restrictive approach of Austrian legislation to IVF is okay. The court finds no breach of Article 8 in the present case. Okay? The court does warn, however, that there might be some changes. There might be some changes because personal autonomy, as I said, is a very strong motor in the development of Article 8 case law in the European Court of Human Rights and in the SH versus Austria case. the court gave a sort of warning by saying, however, the court considers that in this area, assisted reproductive technologies, in which the law appears to be continuously evolving and which is subject to a particularly dynamic development in science and law, needs to be kept under review by the contracting states, right? So this really can be read as a sort of warning to very restrictive approaches such as the Austrian legislation that was at stake in the particular case, to say, okay, I'm not finding a breach right now, but this needs to be under continuous review because there is dynamic interpretation at stake here, okay? So I'll close here for now. We'll have a little break, and when we go back, I'll try to show you also the pressure of more international movements. There's a very interesting case of the Inter-American Court of Human Rights on this particular issue, and then we'll move on to what the market sort of approach does to the issue, okay? So thanks for your attention, and let's have a little break. Grazie mille. Is it possible to do tomorrow? Because it is not finished. I still need to add focus out on the So tomorrow I'll be ready. Okay?
There is a lecture. So what kind of issues are you facing in Romania right now in the democracy?
Police violence, and eviction, eviction of Roma settlers, and similar to the cases that Judge Sachs was presenting, maybe not that
Пока я понимаю, что я что пока я в чем сообщении, то я видел решение подписала я сюрприз. Ну, свои точки зрения, я голос совершенно. Если спишем деле по 5 часов, это не роскошь.
Okay, so I think I'm gonna start again. So as I start again, let me go back to where we were before the break. So what I was trying to explain is the fact that there were some elements in the case law of the European Court of Human Rights that seem to indicate, on the basis of this notion of personal autonomy, a sort of trend or direction towards something like a right to property, or at least the recognition of the legitimacy of people's choice to become or not become genetic parents. As I said, even though there is no explicit acknowledgement of a right to access assisted reproductive technology in the case law of the European Court of Human Rights, there are some elements that are worth taking into account. I guess the first one is the strength of the notion of personal autonomy. We know that this is a notion that is really becoming the core of Article 8 case law, and that is really leading to significant changes on a number of topics. We can talk of end-of-life issues, for example. The European Court of Human Rights is really delivered a number of interesting rulings saying that, you know, one's decision on how to end their life is also something that is protected under Article 8. You know, so it's really a powerful concept. So it needs to be watched. Also because of the sort of warning that the court gave, for example, in the SH versus Austria case that I mentioned just before the break. And the last factor that I wanted to mention that, you know, is also maybe pushing towards that trend that I'm talking about is a number of evolutions in the comparative and international framework. And as I said, I just wanted to mention a very important ruling by the Inter-American Court of Human Rights in 2012 in a case against Costa Rica. What was at stake here was a total ban on in vitro fertilization that was in vigor in Costa Rica. And I just copied a couple of excerpts of the 2012 decision that I think are relevant to our discussion. So this first excerpt is interesting because the Inter-American Court insists that the right to private life, like the European Court of Human Rights, is really the sort of legal grounds that we want to be standing on when we're trying to think about reproductive autonomy, right? So, like the European Court, the Inter-American Court insists that the right to private life has a broad meaning, that it encompasses a number of choices that individuals make, choices pertaining to what they consider to be a good life. And this is a matter of autonomy, it is a matter of dignity of the individual. And so this is interesting in terms of the identification of the relevant legal ground. At the bottom of the slide, you will see the court's conclusion in its analysis of the right to private life. It says the court considers that the decision of whether or not to become a parent is part of the right to private life and includes, in this case, the decision of whether or not to become a mother or a father in the genetic or biological sense, right? So we have something that is akin to what we've seen in the European Court of Human Rights in the Dixon case, for example, which is to say the right to private life is broad. It includes reproductive autonomy in the sense of choice to become or not to become a parent. And it potentially includes this genetic dimension of the decision to become or not to become a parent, right? Then the court moves on. I will circulate the slides, right? So if you know, you'll have it. The second element, the second excerpt that I chose, kind of pushes this previous affirmation further. And interestingly, the Inter-American Court here gives a little bit of detail. It says the right to private life is related to reproductive autonomy. So here we really have the elevation of the concept of reproductive autonomy. It includes access to reproductive health services, which includes the right to have access to the medical technology necessary to exercise this right. Okay, so here we have a very bald affirmation. And the court says the right to reproductive autonomy is also recognized in Article 16E that I showed you before of the Convention on the Elimination of Discrimination Against Women. Okay, you remember we looked at the CEDAW a couple of slides ago here, when the CEDAW 1979 says that the same rights should be granted to both men and women as far as the decision to freely and responsibly make reproductive decisions, right? Number and spacing of their children and access to information, education, and means to enable the exercise of reproductive rights. So the Inter-American Court makes an explicit reference to Article 16E of the CEDAW, and it says that the right 16E is violated when the means by which a woman can exercise the right to control her fertility are restricted, which is also here a very important affirmation. Thus, the protection of private life includes respect for the decision both to become a mother or a father and the couple's decision to become genetic parents, right? So we have the same motto, but we have more detail in terms of access to the technological means to make their reproductive decisions. And finally, the court says the right to private life and reproductive freedom is related to the right to have access to the medical technology necessary to exercise that right. Okay? So this is very interesting because it is also linked, and this is what I highlighted at the bottom of the slide, to a sort of right to development perspective, because the court says that the right to have access to scientific progress in order to exercise reproductive autonomy and the possibility to found a family gives rise to the right to have access to the best healthcare services and assisted reproduction techniques. And therefore, the court here will strike down the Costa Rican ban on in vitro fertilization as disproportionate, right? So because the court has substantiated the nature of the reproductive autonomy and has been into the detail of saying reproductive autonomy entails the right to access reproductive technology, then the total ban on in vitro fertilization appears to be disproportionate and an unnecessary restriction, okay? So this is interesting because it is a very important decision, and it is a decision where we see a very important step towards that trend of affirming a right to property, right, including a right to access assisted reproductive technology when necessary, right? And we have a court that considers that the state decision to ban a particular assisted reproductive technology is therefore disproportionate and unnecessary with regard to the right to reproductive autonomy that it has elevated, right? There are further, this is just for future reference, there are further interesting elements in this decision if you want to go back to it. Because not only did the Inter-American Court find that the ban was disproportionate, it also found that it was discriminatory. Discriminatory because the court has coined infertility as a disease of the reproductive system, and therefore it has a whole passage on disability rights, okay? And the court has also ruled that although infertility can affect both men and women, the use of assisted reproduction technologies is especially related to a woman's body. Even though the ban on IVF is not expressly addressed at women and thus appears neutral, it has a disproportionately negative impact on women. So it also found an instance of sex-based discrimination, okay? This is not something that I have time to go into, but I'm just mentioning this for future reference. For now, I'm really interested in the first part of the ruling, which is just to say that because the right to private life entails reproductive autonomy, and because reproductive autonomy entails access to reproductive services and techniques, then the ban is disproportionate, okay?
So excuse me, just one question. Is discriminatory on the basis of sex only relates to women or the couple of who? So I mean the couple is discriminated or women is discriminated?
No, women are discriminated because reproductive technologies concern their bodies more than they concern the bodies of men. So the ban has a disproportionate impact. It's a form of indirect discrimination, you could say. The ban is facially neutral. The ban, in its phrasing, doesn't target women especially, but the court says that the impact of the ban, although it is facially neutral, disproportionately targets women, and therefore it's a discrimination on the basis of sex. Okay? So this might be the kind of case law, the kind of step in the wider international comparative discussion that might trigger some change in other arenas, such as the European Court of Human Rights that we were looking at before, right? If you contrast this case with the SH versus Austria case that we were looking at before, where it's not a ban on IVF, but it's a ban on heterologous donation of reproductive material, it's very striking to see that the European Court of Human Rights did not find the ban disproportionate, right, whereas here, the Inter-American Court finds the ban disproportionate. So, this might be an element of traction for future evolution of the case law for European Court of Human Rights. But last but not least, another factor that I really want to mention in potential for future evolution of the ways in which the European Court of Human Rights so far has been thinking about reproductive autonomy is the globalization of medicine in general and biomedicine and reproductive medicine in particular, right? So here I will move to what I have been mentioning before, which is the ways in which there is a sort of competing paradigm that needs to be taken into account in legal and political reflections about reproductive autonomy. There not only is this trend, this human rights paradigm, trying to, maybe move closer to the affirmation of a right to procreate, there is an alternative paradigm, a competing paradigm. That is the paradigm of freedom of circulation, freedom of movement, that we could the market, not necessarily in the economic sense of the term, although we can also include that in the conversation, but more so in the fact that at the European level at least, the market has really gone hand in hand with freedoms of circulation, right? So it's really the freedom of circulation part that I'm interested in. So in order to move on to this other paradigm that I think is exerting an increasing pressure on the human rights paradigm, I just want to start out by going back to two excerpts of two decisions of the European Court of Human Rights, that one that we've mentioned before and another one that we haven't mentioned yet. So we'll just look at these two excerpts and then I'll try to tell you what I think is interesting here. So the first is going back to SH versus Austria, the Grand Chamber case of 2011. And this is the paragraph that I want you to read. So the court says that the fact that the Austrian legislature, when enacting the law on artificial procreation, which enshrined the decision not to allow the donation of sperm or ova for in vivo fertilization, is a matter that is of significance in the balancing of the respective interests and cannot be considered solely in the context of the efficient policing of the prohibition. It shows rather that the careful and cautious approach adopted by the Austrian legislator is seeking to reconcile social realities with its approach of principle in the field. In this connection, the court also observes that there is no prohibition under Austrian law on going abroad to seek treatment of infertility that uses artificial procreation techniques not allowed in Austria, and that in the event of a successful treatment, the Civil Code contains clear rules on paternity and maternity that respect the wishes of the parents. Okay? So what is the court saying here? It is saying that there is no disproportionate interference with Article 8 rights, okay? The Austrian legislator wants to have a careful and cautious approach. It's trying to reconcile social realities with its approach of principle, which is one that is made of restriction, a sort of restrictive approach towards assisted reproduction. But what is interesting is that the court also relies on the fact that nothing under Austrian law prevents people from traveling abroad to seek infertility treatment, assisted reproductive techniques, that are forbidden in Austria, okay? Let me move on to the other excerpt that I want you to read, and we'll discuss them afterwards. The other excerpt is from another Grand Chamber case of 2010, which is about the abortion regime in Ireland, right? So you know that Ireland has a very restrictive approach on abortion because the right to life of the unborn child has constitutional value since a referendum of 1982 or 83, I can't remember. And here the court has found, it's a complex case. The court found one violation, but on procedural grounds. So basically, the court found no substantial violation of Article 8 rights in the Irish ban on abortion. But the court said, accordingly, having regard to the right to lawfully travel abroad for an abortion with access to appropriate information and medical care in Ireland, the court does not consider that the prohibition in Ireland of abortion for health and well-being reasons, based as it is on the profound moral views of the Irish people as to the nature of life, blah, 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 exceeds the margin of appreciation accorded in that respect to the Irish state. Therefore, the impugnant prohibition in Ireland struck a fair balance between the right of the first and second applicants to respect for the right of life and the rights invoked on behalf of the people. So interestingly here, the court does the same thing. It says, well, abortion resonates with profound moral values in Ireland, etc. Therefore, because there is a right to lawfully travel for an abortion with appropriate information and medical care outside of Ireland, therefore, there is a fair balance between the right to private life of the applicants and the protection of moral values under the Irish Constitution. Okay? So I find these two cases very, and these two paragraphs in particular, very, interesting, because they really show how these logics of human rights and freedom of circulation intersect, right? Because here what we have is a court, which is the European Court of Human Rights, okay, that is somewhat using the freedom of circulation rationale in order to assess Council of Europe member states' obligations in terms of human rights, right? So basically what the court is saying is, well, as I assess whether the Austrian legislation on assisted reproduction is violating Article 8, or when I assess whether the abortion regime in Ireland is a violation of Article 8 rights, I am going to take into account the fact that nothing under Irish law or under Austrian law prevents people from traveling outside those countries in order to lawfully access the assisted reproductive techniques that are forbidden in Austria, or the abortion procedures that are forbidden in Ireland. Okay? So this really shows that the obligations that fall on states pursuant to the European Convention on Human Rights vary according to the possibility that is offered to people in their jurisdictions to travel and seek elsewhere services that may not be accessible in a particular state, right? Since women in Ireland are not prevented from traveling abroad to seek an abortion, it may be said that the state's will to preserve national prohibition on abortion does not exceed its margin of appreciation. Since there is no prohibition on weighing on Austrian couples to seek fertility treatment abroad, even in the conditions that are prohibited under Austrian law may well remain highly restricted. Yeah.
But in that case, isn't the state responsible to provide some subsidy to those who can't take advantage of those opportunities?
So exactly, this raises a lot of questions. So we'll come to that one. But before that one, because I would call that a sort of empirical problem, I think there also is a principled problem before even coming to the empirical problem. The principled problem with this kind of reasoning is that basically what is left of the project of international human rights norms if individual states are in a position to rely on rights, services, protections that are granted by fellow states in order to get away with the burden of human rights obligations that they have contracted, right? For a court to say, well, no, Ireland isn't really in violation with the European Convention of Human Rights because you know what? Irish women can just go to the UK. What is left of human rights protection, right? If you're relying on freedom of circulation as a means of circumventing national law, then basically you're just exempting national law from the obligation to conform with the international human rights obligation, right? So this is really a mode of reasoning that allows states to shift the burden of international control onto neighbors, onto fellow sovereign states, provided there is freedom of circulation, right? And this really runs contrary to what have long been understood to be the premises of international human rights regimes, and particularly the notion that every state should be judged, and be it the case sanctioned, on the basis of its own performances and credentials, right? You're usually not to get away with your own law, procedures, and human rights standards just because people from your jurisdiction can get away with the rigors that you are imposing on them by traveling abroad. So in that respect, one can find it very disturbing that the fact that abortion would have been accessible to A, B, and C under British law, or that assisted reproduction would have been accessible to SMH under, I don't know, French law, has anything to do with what the court needs to decide when it rules against Ireland or Austria, right? Yeah?
What was the distinction made between the three applicants?
In A, B, and C?
Yeah. Because I see there was no violation for two of them, but then there was violation for
yeah, as I said, it was a violation on procedural grounds, though. Okay? So, okay, so this is just a parenthesis on A, B, and C. A was a woman who had a story of alcoholic behavior, and I think she already had 3 or 4 children that had been taken by social services because she could not take care of her children. And she had been in a rehabilitation program, and she was on the verge of regaining parental authority on her children because she was recovered from alcoholism. And the fact that she would be pregnant, again, would mean that she would not be able to regain authority on her children. Okay? So this was the deal with social services. She was not to have any more children. Okay. The second woman was a woman who was having a, I don't know how to say this in English, extrauterine pregnancy, which is a very severe medical condition. And the third woman was undergoing treatment for cancer, and she could not, was she to take the pregnancy to term, she would have needed to interrupt her treatment for cancer, right? So in all these cases, we're not in situations of, you know, a woman who just doesn't want to have who just wants to have an abortion because she bought a plane ticket and, you know, it's going to ruin her vacation, right? It's really not the model, right? All these women traveled to the UK to get the abortion, and then they encountered a number of legal issues upon returning to Ireland. The court found no violation for the first 2 applicants, and found a violation for the third applicant because the cancer situation was normally something that could have fallen even under Irish law, because there was a threat to the woman's life due to the interruption of the cancer treatment. And therefore, there should have been a procedure available to her to petition the refusal that was the refusal of medical services to grant her permission to abortion, even under Irish law, right? So it's sort of a Tysiak versus Poland, or it's that sort of case law, right? But it's really a violation on procedural grounds. So it's not really relevant to the kind of conversation that I want to have here, which is, I mean, one only needs to focus on the first 2 applicants and see that there was no violation, and built into the no violation conclusion of the court is the notion that they were allowed to travel, right? So this is really what I want to focus on. Yeah.
But again, there was another Irish case, another old one, about the applicant company who were organizing traveling for women abroad in the UK.
That's a
open
door.
Open door.
Yeah. Okay.
Probably. Well, I mean this sort of.
But that's not
a critical argument in ABC and the SH versus Austria. It's sort of like every time when the court doesn't find violation, they try to give a sort of a la carte solution for the applicant. Well, there is no violation, but we will just recommend you, we'll suggest you that you're doing something.
Yeah.
And I think that this freedom of movement argument, like, sort of builds on open door, versus Ireland.
Okay, so I'll go back to Open Door for a second because I'm not sure I agree with you, but we'll have a conversation. But I'll just finish on this because there's another element that needs to be before we have this conversation. So we have, with this line of reasoning, we have the principled problem, right? What's left of international human rights if we can just, if states can shift the burden onto the neighbor. There's also empirical issues that are very, very important. Maybe the European Court of Human Rights reasoned that way because it was ruling against Ireland and Austria that are two EU member states, right? Maybe the court would not have reasoned that way if it were, delivering a judgment in a case against Turkey or Russia or a non-EU member state, right? But whatever the answer is, I don't know what the answer is, right? That question. Is it because it was EU member states or not? But whatever the answer is, we're at risk here of seeing a double standard emerge in the case law of the European Court of Human Rights, right? Because if the court ruled that way because it were EU member states, then it means that you're not under the same human rights obligation when you also have the freedom of circulation that is granted to the people of your jurisdiction, right? And if there is no impact of the EU membership of the two countries on the reasoning of the court, then we have the problem that you were mentioning earlier, which is, what does it mean to say, people can just travel? Who can travel? What is required to travel?
I would like just to say something. I don't think that we have this double standard. The court has this double standard. Maybe the fact that he took into account that it's a country like Austria or Ireland is because they have a higher standard of protection of human rights. Maybe the other states were not already.
Well, that is not official discourse of the European Court of Human Rights.
They were thinking that maybe the other states were not already prepared to accept all these standards, all these, to protect the right to assisted reproductive treatment, things like this. I think the court considered that this is an open door, and for the future, the other countries become also Austria and all the others, but not because.
Yeah, but if your line of reasoning is true, and it might well be, the court doesn't need to rely on the freedom of circulation. It can just say there is no violation. It doesn't need to say.
The door just to say that for the moment, for the time being, this could be solved. It's not so, I don't know, serious.
Well, but it doesn't answer the principal question of what you're doing to human rights standards when you're building in freedom of circulation.
But it can't impose when all the countries are not already prepared for this standard of protection. I think they are.
Yeah, but that's always a difficult conversation to have when you're talking about the European Court of Human Rights, because the European Court of Human Rights has imposed a number of things on a number of states that were not ready, right? I mean, think of Goodwin versus the UK with the right to marry of transgender people. I mean, really?
Yeah, but they are comparing the consensus within the member states usually. So
you think there's a great consensus on the right to marry for transgender people throughout Council of Europe member states? I'm not positive. So, yeah, I mean, it
depends.
Yeah.
I think the consensus thing is mainly used when the court tries to find violations, tries not to find violations, a methodological tool, like positive obligations.
Yeah, I don't think it's a very reliable. I don't think it's a analytical frame that helps explaining all the varieties in the European Court of Human Rights case law. So, but anyway, to go back to what does it mean when you say, well, just go have an abortion abroad or go have assisted reproductive techniques abroad, is the issue of who can go abroad. So what do you need to travel? You need documents? You need money, right? So this is the other issue. When you're saying that, when you're building in the sort of, just go abroad, freedom of circulation rationale into the ways in which you assess the obligations of states in human rights, is that you're also at risk of creating a double standard in that perspective. Maybe not a double standard between countries that belong to the EU and countries that do not belong to the EU, but double standards between people who can travel and people who cannot right? For reasons of, you know, because they're undocumented immigrants, because they're from a poorer background, for a variety of reasons, right? So it's kind of problematic. So now if we go back to open door. So maybe so everybody's on the same page, open door. Shall I refresh your memory?
I think that I still have one question. But when they travel, they are still protected by their government or the government of that country that they arrive to do abortion or something? Because if something happens,
yeah,
who will be responsible for this? Because I mean, the jurisdiction.
What do you mean if something happens? If there's medical malpractice or something like that?
Yeah.
This will be covered by, in the EU,
yeah.
this will be covered by the Directive on Cross-Border Care, right? So the 2011 Directive on Cross-Border Care sort of deals with the situation of which system of Social Security will reimburse the cost and be in the case of the liability issues of medical care that is obtained in a country other than the country of residence. So you have a clear framework, again, within the EU. So of course you have more protection if you are in the EU, absolutely. So to go back to the open door situation, which is actually a very interesting case. So in the early 1990s, student organizations were disseminating information in Ireland about abortion clinics and abortion services and procedures in England, okay? And there are actually two judicial decisions here, because first, what happened was that the High Court in Ireland delivered an injunction against the student organizations, prohibiting them from disseminating the information about abortion in England because of the constitutional ban in Ireland. And the student organizations petitioned the injunction, the ban, and the High Court in Ireland made a referral to the Court of Justice of the European Union to say, is the prohibition on the dissemination of information a violation of the freedom of circulation of services under EU law? Okay, this was the first European court decision. And this is the Grogan versus Society for the Protection of Unborn Children case of 1991, judgment by the European Court of Justice. And the Court of Justice said, medical services are services under EU law. So medical services go with freedom of circulation of services. Second thing the European Court of Justice said, I'm not going into the moral discussion. I don't care if this is abortion or plastic surgery or life-threatening heart condition. It's service. So abortion, like any other medical service, is a service under EU law. Okay. Then it said, freedom of services goes with freedom of information about services. Okay? So normally, a ban on the dissemination of information about medical services within the EU is a violation of EU law. But here there is no violation. Why? Because the students' organizations are not related to the British clinics that do the abortion. So who is entitled to the freedom of services and freedom of circulation of information about the services? It's the British clinics. The British clinics are allowed to rely on EU law to make advertisement about abortion in Ireland, right? But if you ban the student organizations from delivering a message, there's no link between the two. So they have no freedom of services and freedom of information of services to claim, right? So it's interesting because the European Court of Justice said there was no violation of EU law when Irish authorities banned student organizations from disseminating information about abortion in England. but only because there is no legal link between the student organizations and the British clinics. The most interesting part of the judgment being that abortion is a service under EU law. Then the exact same facts led to a case before the European Court of Human Rights. And the European Court of Human Rights delivered its ruling in 1992 in the Open Door and Dublin Well Women versus Ireland case. But here, it was framed as a freedom of expression case, okay? So what the student organizations were claiming is that their freedom of expression had been violated by the ban. And the European Court of Human Rights said, well, there is a violation because it's a total ban, it's disproportionate. Is that what the court said? I think that's what the court said. But what is interesting in this case is that Open Door is not a case about abortion. The European Court of Human Rights says nothing about abortion. It's just a very classic freedom of expression case, okay? Yeah, you have a right to say something. If you have a total ban, it's probably going to be disproportionate, okay? See, I don't even really, I'm not even 100% sure of the outcome of the case because for me, it's really not an interesting case. It's a very classic freedom of expression case. I can't even remember which way it went. I think it said, yeah, it said there was a violation. It was disproportionate. Now I'm sure. A little slow here, this one is good. But really what is striking is that the European Court of Human Rights says nothing about abortion. It's only an Article 10 freedom of expression case. Okay? So it's really striking because people usually remember this case by saying the European Court of Justice found no violation and the European Court of Human Rights protects more human rights, therefore reproductive autonomy finds a violation. But the truth is that the most important thing that has been said by these courts on the topic of abortion was said by the European Court of Justice when the European Court of Justice said that abortion was a service under medical law, under EU law. And not by the European Court of Human Rights, who said really nothing about abortion, just said whatever, it's a freedom of expression issue.
But they were not asked about that.
They were not asked about it, yeah.
I think that like in any Article 10 case, there can be a sort of restriction posed on liberty of expression, like in many cases hate speech. Like this, I think the European Court could have stepped on this profound moral views of the Irish people ground in Open Door too.
To regulate the expression about what other countries are doing?
What I mean that in Article 10 there is always a sort of restriction posed on liberty of expression, and hypothetically the court could have used this path too in Open Door.
I mean, you can always say the court could have done something else, but the truth is that it's a very classic Article 10 decision. It doesn't contrast with what the European Court usually says in freedom of expression cases. And I agree that, the court wasn't asked to rule on Article 8, for example. But what I find interesting is that everyone recalls this case as an abortion case, but the court says nothing about this case.
When I said open door, I don't refer to this case at all. I was saying that the court, the European Court of
he
Human
was
Rights,
mentioning that case.
that opened the door
I
for the
understood that.
development of human rights. So
I understood that, but I was answering to his question.
further with, with protection of the right to use these techniques and everything.
So does that answer your question anyway about the court?
Yes.
Okay, so here we have these two excerpts of SH versus Austria and ABC versus Ireland that really show that this intersection of human rights and freedom of circulation raises difficult questions, right? And it can be problematic and it can be worrisome in terms of, as we said, creating double standards, shifting the burden of state obligations in terms of human rights onto other countries, etc. What this allows me to do is just maybe open up the discussion on medical tourism, and for that matter, on reproductive tourism. That is, of course, a very complex matter. Because to be kept in mind is that if we focus on the EU for a minute, so leave the Council of Europe wider framework, but if we look at the EU, as you know, the free movement of persons was initially reserved to workers, right? The history, the genealogy of the free movement of persons is the free movement of workers. And today, Article 21 of the Treaty on the Functioning of the European Union, freedom of circulation of persons is open to all European citizens. European citizens, when they are patients, they can rely on the free movement of persons to go elsewhere within the EU to access medical care, even if they do that in order to access medical care that is not available to them in their home country or in their country of residence, right? So they can do that because the medical care in question is illegal in their country. They can do that because the medical care in question is hardly accessible because there's like a super long waiting list, for example, in their country. They can do that because the medical care is very expensive in their country and it will be cheaper in another country. There's a variety of reasons for which European citizens may choose to travel for medical care, but all of them are legal in the sense that European citizens have a fundamental right to free circulation within the EU. And this is why it is really important to understand that medical services are services under EU law. And this has been established a long time ago by the European Court of Justice. As early as 1984, the court said the freedom of services includes the freedom of recipients of services to travel to another member state in order to access a service that is restrictively delivered in their country of residence, right? And this has been extended to medical services for a long time. So what I'm trying to say here is that the logic of the freedom of of the free movement, right, freedom of circulation of services of persons, encapsulates the possibility of medical tourism, right? So it's one thing to say that we need to have an ethical reflection on medical tourism or reproductive tourism. But what we really need to do also as lawyers or as law-sensitive people is to also take into account the fact that it's way too easy, way too simplistic to say that medical tourism is illegal. Because it's not illegal. Because in the European Union, these freedoms of circulation have constitutional value, right? So they are the pillars of the European Union. And there is no question that the court and directives have acknowledged the fact that European citizens can be patients, and as patients, they are allowed to rely on the free circulation of persons and of services to obtain care that they cannot access, at least in the conditions that they desire or that they can afford in their country of residence, right? This is built into the European Union law, right? And the text that I was mentioning before, the 2011 Directive on Cross-Border Medical Care, only reinforces that. If you have a directive on cross-border medical care, it is just an additional illustration of the fact that the possibility of medical tourism really is not a legal problem. I mean, it's not illegal. It's certainly not illegal. You have a whole directive that aims at planning who is going to pay for what are the procedures for the reimbursement on your own national social security scheme for care you might have obtained in another country, etc., right? So this is really important. And therefore, sometimes it is said that the European Union doesn't have a lot of competences in the field of health, for example, right? Or in the field of health law, and even more so bioethics or biomedical law. But the EU doesn't really need to have those competences for EU law to be very relevant to the kind of discussion we're having, because it's not a matter of competences in a particular sector, it's a matter of freedom of circulation, right? So just the pillar of the freedom of circulation is making EU law very relevant to a growing number of cases today and certainly in the future, right? Because this is only going to develop, right? So I thought I would give illustrations of this on how the European Court of Justice has been increasingly dealing with not the freedom of circulation per se, because I've said what I wanted to say on this, but if we look at, on the basis of this notion that EU law is going to be more and more relevant in the field of bioethics, biomedicine, there's a number of cases that we can look at to see what kind of legal discourse the European Court of Justice, the Court of Justice of the European Union, is delivering in these cases, right? So there's two final cases that I wanted to mention with you that are the Sabine Meyer case of 2008 and a more recent CD and ST and Z versus A case of 2014. So let's look first at the 2008 case. This is a case, it's both preliminary references cases, and here there was a referral made to the Court of Justice of the European Union relative to the extent of protection offered by EU labor law and EU anti-discrimination law to a female worker who was enrolled in an IVF cycle, right? So you have a female worker. She is enrolled in an IVF cycle. So IVF takes place, and just the day after or 2 days after, okay? So the embryos are not implanted yet, right? The in vitro fertilization has taken place, but the embryos are still in vitro. They're not in her body, okay? And she believes that she has been fired because she was going to be pregnant. And as you all know, it's impossible to fire a pregnant woman, right? Under EU law. So the question before the European Court of Justice is, do the EU protection for pregnant workers apply in this situation? And it's very interesting to see the answer of the European Court of Justice. So the Court of Justice says that as a matter of general rule, this is the first of the paragraphs that are copy-pasted here, it is the earliest possible date in a pregnancy which must be chosen to ensure the safety and protection of pregnant workers, okay? This is the protective nature of EU labor law, right? You're gonna protect pregnant women and you're gonna protect them from as early as possible, right? However, even allowing, in regard to in vitro fertilization, that the date is that of the transfer of the fertilized ova into the woman's uterus, it cannot be accepted, for reasons connected with the principle of legal certainty, that the protection established by the directive may be extended to a worker when on the date she was given notice of her dismissal, the in vitro fertilized ova had not yet been transferred into her uterus, right? So what the court is saying, okay, we cannot, it is impossible, even if we try to stretch it in the most protective fashion, it is not possible to consider that this woman was pregnant, right? Even if we accept that protection could have started the day of the transfer in the uterus without even knowing if there is going to be a pregnancy, we cannot reasonably extend that one step further up the road, and we cannot consider that the fertilization, the in vitro fertilization, amounts to pregnancy. Okay? But then the court could have stopped there, saying, well, tough luck. You're claiming the protection of the pregnant worker directive, but you're not pregnant, so you're not protected, right? And it could have been end of the discussion. What is the court doing? It continues. And it does something really remarkable, is that it will decide to invoke another source of EU law to still find a way to grant protection to this woman. So what does it do? It goes on. Workers of both sexes can be temporarily prevented from carrying out their work on account of the medical treatment they must receive. Nevertheless, the treatment in question in the main proceedings, the assisted reproductive technique, directly affects only women, right? Of course, the implantation of fertilized embryos in a uterus only takes place on a woman, okay? So what will the court say? It says this particular technique, this particular medical procedure affects only women. Therefore, the dismissal of a female worker, essentially because she is undergoing that important stage of in vitro fertilization treatment, constitute direct discrimination on the grounds of sex. To allow an employer to dismiss a female worker in circumstances such as those in the main proceedings would moreover be contrary to the objective of protection of Directive 76 on equal treatment in the workplace, insofar as the dismissal is essentially based on the fact of the in vitro fertilization treatment, and in particular on the specific procedures which such treatment involves. Consequently, Directive 76, so on equal treatment, not the Pregnant Workers Directive, but the Equal Treatment Directive, preclude the dismissal of the female worker who, in circumstances such as those in the main proceedings, is at an advanced stage of in vitro fertilization treatment, that is, between the puncture and the transfer of the in vitro fertilized ova into her uterus, inasmuch as it is established that the dismissal is essentially based on the fact that the woman has undergone such treatment. So the court, as you see, cannot apply the Pregnant Workers Directive because the woman is not pregnant, but will move on to the Equal Treatment Directive and say, we need to find a protection for women undergoing IVF treatment because only women are undergoing IVF treatment, and therefore dismissal pronounced by an employer who knows, who has knowledge of the fact that his employee is undergoing IVF treatment amounts to discrimination on the grounds of sex. Okay? This is the reasoning of the Court of Justice. Okay? So this is a very important, very creative decision by the European Court of Justice that shows that the court is doing something really bold. It is mobilizing and fully applying legal categories that EU law is made of to situations that, of course, I mean, no one had this kind of case in mind, especially in 76, on the Directive on Equal Treatment, right? Certainly not thought of for protecting women undergoing IVF treatment, okay? So this is very interesting, and it's good that we had the conversation about Grogan just before the abortion 1991 Court of Justice of the European Union case, because it's the same thing. What do we see in Grogan? The Court of Justice says, well, I'm not even going into the moral conversation. I'm just saying that for me, medical services are services, abortion services are medical services, so abortion is a service under EU law. What is the court doing here? I didn't reproduce these paragraphs, but it says the same thing. It says, I'm not even going into the moral, the discussion about how touchy assisted reproductive technology and regulation is, etc. I'm only looking at EU law categories. And what I'm saying is, well, my understanding of equal treatment between male and female workers encompasses a situation where a female worker is dismissed when her employer has the knowledge that she is undergoing IVF treatment. And I'm constructing this as discrimination on the basis of sex, right? And there's other examples we could take. There's, for example, interesting rulings of the European Court of Justice on prostitution, where the European Court of Justice says, well, I'm not even going into the moral assessment of prostitution. Of course, countries can have different approaches of prostitution, etc. But as far as free movement of workers, I'm considering prostitutes as independent workers. This is the legal category that is relevant for the Court of Justice of the European Union vis-a-vis prostitution. Okay? So what I'm just trying to say here is that what is really interesting is that in all these cases that are, sensitive cases, where probably morals are involved. The Court of Justice of the European Union tends to have a very bold approach by pretending to have a merely mechanical application of legal categories. This is a service, this is an independent worker, this is sex discrimination, without really paying too much attention to, you know, like contrary to what the European Court of Human Rights does, saying, oh, abortion is profound moral values for Ireland, or it is a very cautious approach for the Austrian legislator. This is something that you really do not find in the legal reasoning of the European Court of Justice.
Just a first remark, I think this is mainly because the European Court of Justice has nothing to rely on when it would speak about morals or profound moral views. Because the European Convention has this second paragraph, Article 8. Well, there is a sort of restriction imposed, and there are different principles on which the European Court can rely on, speaking and finding no violation. But I had another question concerning the Court of Justice. There was this ruling, I haven't read it, about ban on blood donors. Was the same principle applied? About ban, I think, on homosexuals donating blood. Was it the same principle? Also, like, we do not want to see any moral justification or any moral argument?
I will check tonight. I'm not sure.
Because it touches on practically the same.
Yeah, that's a very good. That would be a very good element of compilation. I'll look at it tonight in detail. I mean, I know the case, but
yeah,
I cannot answer in detail your question.
I like read some articles, but
yeah.
After question just about details. So did this court of justice determine the starting date from where the dismissal of worker would be considered as discrimination? I mean, the start of the cycle of first consultation?
No, it didn't have to decide the date because it's not the Pregnant Worker Directive.
No, I mean the second one, the equal treatment directive. Because
this one, the 76.
Yes.
207. You don't have to determine the date.
Yeah.
It's the sole fact that the employer had the knowledge of the IVF cycle that makes the firing a sex discrimination.
So the cycle should start not just the first consultation when the employer sees that his employee is going to the medical clinics that it's specialized basically in IVF.
It's not so much in terms of dates, it's in terms of information of the employer. Because the employee told her employer she wasn't in IVF cycle, so the court didn't have to decide precisely on a date or on a fact, right? It just decided that the fact that the employer had the knowledge made it plausible that this was the reason for the dismissal, and because IVF treatment is only undergone by women, it is sex discrimination. So it's not a matter of date, it's a matter of knowledge. You know what I'm saying?
Yeah, the different degrees of knowledge. You say,
But that's very classic in terms of protection against firing for knowledge of pregnancy. I mean, if I tell my employer that I'm pregnant and I'm not pregnant, and they fire me, well, I'm still protected because they fire me because I'm pregnant, even though I'm not pregnant. You know what I'm saying? It's not a matter of truth, it's a matter of knowledge. So it's not a matter of date, or it's a matter of knowledge. Employers are not allowed to fire their employees because they're pregnant. I wanted to say something on your first observation, but I can't remember what it is. What was your first comment? Oh yeah, the paragraph 2. Yes and no. Of course you can say the European Court of Human Rights has more reason to...
it's not reason, grounds.
Has more grounds, okay, has more grounds for entering into the sort of moral axiological conversation with choices made by states. But it would also be an illusion to take the Court of Justice of the European Union's word for not saying anything moral. The Court of Justice of the European Union says, I'm not going into morals. But of course she is. I mean, it is a moral statement. Even if you say, I'm not going into morals, it is a moral statement to say that prostitutes are autonomous, what was the category? Self-employed. Yeah, I have it out right now. Yeah, self-employed workers. Or it is a moral statement to say abortion is a service like any other medical service. I mean, a lot of holders of particular moral views are going to find that this is morally very offensive, right? So, you know, it's not a matter of grounds. The truth is that the minute you produce a legal discourse, you know, it's going to be situated.
Yeah.
So even if you say, I'm not looking at the morality of abortion, the sole fact of saying, well, it's a service like any other service, of course you're also producing something.
Well, you're producing a moral statement, but you cannot use this argument because you just have no legal grounds to use it. When the Court of Justice says, we will not
But you
look
do
at
have
the
legal
law,
grounds,
we
because
cannot
in
look
the
at it.
EU law, you have restrictions on harmonization, etc., for reasons of public order that have to do, that encompass precisely those very deep down axiological traces. Yeah.
The difference between the two courts is the fact that the European Court of Justice in Luxembourg is using, you know, it's applying the European law. The European Court of Human Rights is using the convention, and the convention is very restrictive. It's from 50s, and you know the European law is developing, and you know the court cannot afford. Sometimes it's criticized exactly because of this. They said at the beginning we didn't have in our mind, you know, to develop the case law as you do European Court of Human Rights. This is, you know, the main critic at the moment against European Court of Human Rights. They said you are expanding too much. We are trying to do this. Normal, but you know it's very easy for the European Court of Justice to, you know, to apply directives and to go further with say, okay, we're going to morals, but you know, we apply this. Discriminatory treatment is very easy. It's easier for them to, you know, to do this in this way.
Yeah, that's probably part of the conversation. I'm not sure it's totally determinative. And I have the last case I want to show you. Will maybe run counter that argument a little bit, but you're absolutely right that EU law, because of the development of all the legislation in the EU and all the directives, etc., of course, impact greatly on the interpretation that the court can have. But you know, the politics of acceptance of the word of the court also have to do with other elements. I mean, it's not only because EU law is more rich with, you know, body of anti-discrimination law, etc. It's also smaller. It's also the, you know, the politics between the court and the states.
I wanted to say just European countries.
Exactly.
European Court, you know, have 47 countries. So
it's not the same politics of legitimacy of the court. But I'm going to show you a case by the Court of Justice of the European Union that shows that it doesn't always go that way, like in the.
And I think the European Court doesn't always go that way neither, because you have lots of cases that can circumvent its own principle, like look at Valenatos versus Greece and other cases. It could have adopted the same view as an ABC and say like, this is against morals of the Greek people. Well, it didn't say that. It said it was discrimination, that this sort of couples can't, it was a civil union case, and other cannot. So I think it's like the choice. You can it's probably the pension position also that matters.
Yeah, no, certainly. Well, there's something I wanted to say, but we're going to go too far, so I'll just move on to the last case that I wanted to mention with you. So, for example, the Sabine Meyer case is one possible illustration of the fact that reasoning on the basis of the legal categories of EU law does not necessarily lead to the same results as reasoning from the legal categories that European Convention of Human Rights law is made, okay? So this is a sort of a little bit of a contrast between the two, but this contrast only holds true to a certain point. And they are tipping point or vexed issues that lead even the Court of Justice of the European Union to withdraw from a morally agnostic view, right? So the one case that I want to show, and it goes back to a topic that we were mentioning before, which is the topic of surrogacy. I find it really excuse me, very interesting. A case that was ruled 1 year ago in Luxembourg and illustrates a sort of surrogacy exceptionalism, right? So on all these cases, abortion, assisted reproduction, prostitution, and we could probably, make the list a little longer. As I said, there are illustrations of the sort of agnostic position of the Court of Justice of the European Union that says, I'm not really looking into the morals of this, I'm just applying I'm doing the mechanical work of applying my legal categories, right? Well, it chose not to do so in a case involving surrogacy that was brought before the court in Luxembourg just over a year ago. So what was the situation here? We had two female employers, one in Ireland and one in England, who had become mothers after a surrogacy agreement, okay? So in England, surrogacy, as I said, is legal. And so the British female worker had become a legal mother pursuant to English law. She had a judicial order that said that she was the mother of the child that had been born to another woman who was the surrogate. In Ireland, surrogacy is not prohibited. I mean, there's no specific text. And the mother, the woman, was the mother because the surrogacy agreement had taken place in California. And as I mentioned before, in California, on the birth certificate, when there is a surrogacy agreement, the only woman who appears is the commissioning mother, right? Not the surrogate, not the gestational mother, who doesn't exist legally, okay? So the Irish woman was the mother because on the birth certificate of the kid, she was the mother, right? So how else can you be a mother? Okay, so these two women are legally mothers under their own national laws, right? And because they're workers, they claim maternity leave, okay? And they're denied maternity leave. So Irish court and British court refer the question to the Court of Justice of the European Union. So the directive on maternity leave is a 1992 directive. And the 1992 directive grants all women of the European Union the possibility of enjoying a leave because of pregnancy, because of giving birth, and because of breastfeeding, right? These are the three grounds for the leave. And in this particular case, the Court of Justice of the European Union read the directive and said, well, these women cannot claim a maternity leave because the notion of maternity in the 1992 directive requires that the woman was pregnant and gave birth, right? So it gives a definition of the notion of maternity as implying necessarily a pregnancy and the fact of giving birth, okay? Okay, so if you look at it that way, you're like, okay, whatever, this is a definition of maternity. It is a possible definition of maternity. What is very interesting is to contrast this decision that was delivered in March 2014 to the previous case law of the European Court of Justice on these protections, maternity leave for pregnancy, giving birth, and breastfeeding, right? And what is very interesting is that in previous case law, the Court of Justice of the European Union had insisted on the necessity to understand maternity as a social role, as referring not to the biological condition of maternity, but as referring to the social role of parenting, right? So the whole case law of the Court of Justice of the European Union was to say, this is a maternity leave is a protection for workers in order to help them conciliate work life and private life, right? So workers need to be helped in the conciliation between their professional activities and their social role as a parent. In other words, the case law of the Court of Justice of the European Union on this same directive, previous to this decision, was really to give a totally non-biological understanding of maternity, and to the contrary, to really insist that it was the social value of parenthood that was being protected throughout the directive, okay? To the extent that in 2010, the Court of Justice of the European Union granted a breastfeeding leave to a father, right? So this is to show you that it really was a case law about disconnecting any biological understanding of maternity or parenthood, and really valuing the protection of parenthood as a social responsibility, right? So this was the Pedro Manuel Roca Alvarez case, of which you have just one paragraph. The court says that for the Spanish government to submit that only status is that of an employed person is the holder of the right to qualify for the leave at issue, which was a breastfeeding leave, whereas a father with the same status can only enjoy this right but not be the holder of it, is liable to perpetuate additional distribution of the roles of women and men by keeping men in a role subsidiary to that of women in relation to the exercise of their parental duties, right? So the court is saying we cannot exclude men from these leaves because this is the perpetuation of gender-based stereotypes. This is the perpetuation of stereotypes that only women are to take care of infants and small children, and therefore we cannot accept that the Spanish government is ruling out male workers from these leaves. And this is all the more striking that it is breastfeeding. Like, of course, men cannot breastfeed. They can change diapers, but they cannot breastfeed. So, what I find interesting here is that in 2014, the court really changes its approach of the notion of maternity, because it really gives this definition that Directive 92/85 presupposes that the worker entitled to such a leave has been pregnant and has given birth to the child, right? So this is a very bodily, very physiological understanding of the legal category at stake, which is the category of maternity, right? So this is interesting. I find this to be a sign of surrogacy exceptionalism, because as I said before, I think surrogacy is really a very difficult topic that raises a number of issues, and I really think that this is such at odds with the very well-established case law of the Court of Justice of the European Union on the directive of 1992, that it's really just because it was a case of surrogacy, right? And so the court just did not want the court probably felt that there was an issue of political responsibility had her message been to say that commissioning mothers can have maternity leaves, right? And just to close on this, if you're interested in this case, what is really interesting is also to go and read the opinion of Advocate General Julian Cocotte, who was the Advocate General in this particular case, because she was not heard by the court, but was proposing something very, very interesting. That was to say that the commissioning mother should have the maternity leave because they were mothers under British law, under Irish law. So this is the first time that you have mothers, female workers, that are denied maternity leave, okay? So Cocotte was saying that they should get a maternity leave, but she was also saying that the court needed to find a way to extend part of the maternity leave to the gestational mother, which is very interesting in terms of everything that we mentioned before of the gender, class, race, inequality issue in surrogacy. If the European Union would find a way to extend at least part of the protection that mothers can claim under EU law, or parents can claim under EU law, to gestational mothers, this would really be, I think it's a very interesting path of reflection with regard to the challenges that we were mentioning before. And so really, the opinion of Advocate General, so she was saying, you know, she didn't come up with a precise calculation. She said, you know, we would need to reflect on this, but the concept of the eligibility of both the gestational mother and the mother, the legal mother, was I thought a very, very thought-provoking element of the opinion. So as you see, the Court of Justice is not always in this bold mechanical application of categories of EU law, because here, I mean, there were mothers, there were workers, they could have gotten very, you know, mechanically, they could have gotten maternity. So here you see the court kind of moving back. So this is pretty much what I wanted to say for this morning. I'm trying to, I hope I've convinced you that, of course, the human rights discourse and the human rights norm are very important in the field of assisted reproduction, and you know, and they really help us think and frame the debate. But really, increasingly, the freedoms of circulation, on the one hand, and the plain categories of EU law, on the other hand, are increasingly going to be called upon also to adjudicate and regulate these issues of assisted reproduction. So I really think both perspectives need to be thought together when we're trying to reflect on the legal and political stakes of assisted reproduction.
I just have a question on the literature of accessing these cases. I'm still not, I don't have a computer at my where I'm staying, so can we access them next door, like in the computer room? Like,
I have no idea. I mean, if you have access to the computers, yeah.
Yeah.
All the cases are on the websites of both the
can we
courts.
print them off? Are we allowed?
This is the first time I come in this building. I don't know what your privileges are in terms of. So I really have no idea. What I can tell you is that I will circulate the PowerPoint tomorrow. So you'll have all the excerpts and the references. And so, you know, for the future, it'll be easy for you to retrieve the cases. But for right now, I don't know. You have to ask the organizers of the.
How do you have a password again? Like, I don't know how to get.
No, to access the cases, you don't need any password. You go on the website of the European Court of Justice or the European Court of Human Rights.
Oh.
The European Court of Human Rights has a database called HUDOC, H-U-D-O-C. So you find the cases there, either with the name of the parties or the number of the case. And I mean, for the European, you can even just go on Google and you type the names and it comes out.
I have a question about the case about Costa Rica, Octavia Murillo case.
Yeah.
I'm curious if you know what was the aftermath of the judgment and if the law changed in Costa Rica after that judgment concerning the ban.
I believe it has, but I cannot go. We can look. I can try to find the information tonight. I think I read something on the leaflet of one of the NGOs that was really involved in the litigation that that amendments to the legislation were started, but I must confess I'm not absolutely sure if they, you know, went to the, yeah. But I can try to find the information.
A question about the last case. It's a twofold question. First, was there any benefits for adopting parents in Ireland and Great Britain? Second, if they were, did they refer in this case to this allowance, parental leave?
So that's a very good question. The reason for which it was left out of the case is that leave for adoption is not under EU law. So the EU directive makes maternity leave compulsory, but leave for adoption is up to every individual state. So this was not a ground for litigation at the EU level. But in some states, you're absolutely right. It could be a way for commissioning parents to obtain leave. Absolutely.
But it's not applicable.
Well, it's not compulsory under EU law. So EU law is, you know, the Court of Justice cannot impose states to have adoptive leave.
No, it can impose, but the parents can go to the E for a justice in Strasbourg.
No, because there's no directive, there's no legal ground here.
Okay.
You go to national court.
Okay.
Any other question? So maybe you need some food?
Yeah.
So we'll meet again later today at 2:30, I believe in this same room. And we'll talk a little bit about human genetics. Okay?
So basically, the outlines and general principles and other apply to but on the web page, the database, you can find little summaries, like 200 paragraphs.
După tuturor se pot năcriti pe toate nivelurile, fiindcă merge prea departe să mâncăm scărcate informații așa. Se face scărcate, adică se face state, morale, se face fără directe, 4 de state care vin în background, jumătate de la televizoare, care de rest. Nu știu la nivel de Uniunea Europeană, tot aceeași chestie, că mai multe regulate, nu de la noi, vorbeam înainte, aș merge să analizăm nevoie de toate. Au alt rol, au altă abordare. Ce cred eu până la urmă că va trebui foarte mult, ca să-mi dată idee foarte bună, adică mă dau seama că trebuie neapărat să colaborăm de toate. Dar în vedere altfel, știi? Da.
You have a information for details? No, I didn't write the register there, so otherwise, no, I
vedi dove arrivano i due cavalletti? Ma perché uno registra e uno con streaming?
Sì.
Che foto sono queste?
Dove stanno?
Questa stanza qui è nuova, è dedicata sì, per le lezioni.
Dove lo faremo? In piedi, sul seduto?
Non so, anche consiglio tecnico a livello di un'inquadratura.
Ah, dove?
Per un'inquadratura decente, io lo farei sul tavolo lì per fargli vedere che ha un po' di mezzo busto sul...
Seduto?
Sì.
Sì. Cioè,
Guarda,
o
questo
legno
possiamo
o il
salire.
coso?
Questo possiamo farlo salire in realtà. O anche scendere.
Sì, penso veramente
Come che sale questa cosa? Sì.
Eh?
Come che sale questo?
C'è un telecomandino, devi aprire.
l'ultimo coso.
No, 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 non è là. Apri gli scomparti sopra il tavolo. In quello là che l'unico che non avete ancora aperto. No, là.